Hi guys, I'm going to be talking about the really interesting matter of AMCU and others versus ANGLO Gold ASHANTI Limited. It's a recent Constitutional Court case decision concerning secondary strikes which took place at the ANGLO Gold mine. Now, the main strike was taking place at ANGLO Gold, and ANGLO Gold ASHANTI, the strike went on for 5 months. Now, what happened was that there was AMCU went around and they managed to gather sympathy support from other businesses in the area. And these businesses in the area also went on strike in sympathy. The employees of these businesses went on strike in sympathy of the employees of ANGLO Gold ASHANTI. Now, what happened was that, you see, for secondary strikes to take place, you only need very few requirements to take place. All you need is to give 7 days notice of the strike. But if it is disproportionate to the actual initial strike or disproportionate in regard to the unreasonableness of it, then it can become illegal. So the question the court looked at, which was on constitutional court level, once it already gone to the Labour Court and the Labour Appeal Court, who had dismissed the matter, they considered the section 66(2) of the Labour Relations Act, which sets out that no person may take place in the secondary strike unless the primary strike is lawful and unless 7 days notice is given. And the most important one, section C, which says the nature and extent of the secondary strike is reasonable in relation to the possible direct or indirect effect that the secondary strike may have on the business of the primary employer. Now, that sounds like a lot of stuff. And what's important is there only are 6 issues really to look at in this matter. Well, the first one is effect. Does it have an effect on the employer and on the primary employer and the secondary employer? Is that a possible relation to, in other words, is the indirect or possible effect of that matter? That's a very low bar. And that means that, it can easily be proven that that does have an effect. Most strikes will have an effect on the employer as long as they're related businesses. Now, the third point is on the business of the primary employer. Now, does it have an effect on the business of the primary employer? In other words, is the business of the second employer related to the business of the employer? In other words, it could be a supplier or, a delivery of coal or something like that to the mine, or even taking away. They could be a customer of the mine. And then the fifth one is the reasonableness in terms of the second employer. That comes to proportionality. And the sixth one is the proportional assessment. Now, what the Constitutional Court looked at here, despite the fact that the case was moot, which means that the matter was already decided because the primary strike had long since fallen away, and there was nothing in that regard taking place 5 months all the way in 2020. But this was an important matter which was then heard on 2021, many months later, by the Constitutional Court, by various judges. And the main judge in this matter was Pillay A.J., who had made the main decision, with Jafta A.J. concurring in regards to costs and Thron concurring as well. So all the judges, most judges, concurred in regards to the first judgment, which set out that the proportionality is the issue. And they found that unless the matter is disproportionate, in other words, once the strikers go on strike, if they are causing violence or the like, and the violence that they're causing is disproportionate to the actions of the primary strike, then that would be found to be illegal. So what you could find is that the secondary employees could be on a legal strike, and then later on the strike itself could become illegal. And the most important sections of the paragraphs of the case to be looked at are paragraphs 66 to 93, where Pillay AJ sets out what exactly proportionality is and what is important in that regard. And they found that the nature and extent of the secondary strike is reasonable in relation to the effects that the secondary strike may have. So one needs to look at what is proportional and what effect the secondary strike can have on the employer. Now, if the secondary strike is disproportionate and totally out of control, then it would be seen to be illegal. So well done to all the guys who were bringing it on behalf of the company, the mine, which was successful, but they lost their costs orders of the Labour Court and the Labour Appeal Court, in the sense that the court found that there was an ongoing relationship and there was no need for costs in this issue. But as said, earlier on, the matter was moot. But what's important in this matter that you take away is that a secondary strike can take place very easily, but once it goes out of control, then it is found to be illegal. Hope you enjoyed the talk. Thanks, guys.